Good afternoon, everybody, and thank you, Ms. Nikak. I trust we are good to go in terms of IT.
Good afternoon, Chairperson, and everybody on the platform. Yes, we are.
Thank you very much, and thank you, honourable members, for joining us. I see we are quorate. A warm welcome to you all to this meeting of the Standing Committee on Agriculture, Environmental Affairs and Development Planning. Today is Tuesday, the 15th of August, 2023. It has just gone 1300 hours, 1 o'clock. And this meeting is a virtual meeting being streamed via MS Teams, but also available on the YouTube channel. As I've said, a warm welcome to you all. Today we are to receive the responses from the national departments, both agriculture as well as in terms of our designation in the Western Cape, environmental affairs, on the bills that we advertised for public comment. And therefore we've also been joined, and I'm grateful to welcome to this meeting a number of people that have commented from the Western Cape on these particular bills. A warm welcome also to our officials in support of us, and a specific or special word of welcome to those from the national government that will be responding to the comments today. Honourable members, my name is Hendrikus van der Westhuizen. I'm privileged to chair this Standing Committee on Agriculture, Environmental Affairs and Development Planning. And if I could just ask the members who have joined us this afternoon to also introduce themselves. Over to you, Honourables.
Thank you,
Good
Chair.
afternoon, Chair. My name is Derek America and I'm a member of the committee.
Good afternoon, Chair. Kayla Murray, member of the committee.
Thank you very much. I believe those are the members online currently. I did receive an apology from the Honourable Pat Maran, who is unfortunately only able to join us in probably about 15 minutes from now. Then perhaps if I could start with the officials from the national departments representing the national here with us today. Can I start with from those that are going to participate on the Veld and Forest bill? Not yet. And then can we, I ask that those of you that are going to respond on the Agricultural Product Standards Amendment Bill, please introduce yourselves.
Good morning, Chair. It's Billy Makafula here from the Department of Agriculture, Directorate of Food Safety and Quality Assurance.
I've said a warm welcome and thank you for joining us this afternoon. It may be that some of the colleagues decided to also only join us later on, as we will first be dealing with the Agricultural Product Standards Amendment Bill. And then it's also my honour to welcome the Honourable Peter Murray for joining us this afternoon. Over to you, Honourable Murray. I believe you are on mute, sir.
Thank you. I'm Peter Murray. I'm honoured to be a member of this committee.
Thank you. And as I've said, a warm welcome to you. Then there are a number of members of the public that also asked to join us today. And I wonder if I could ask if they have been able to join us. I haven't been able to see all the names on the screen yet, but I do know that some of those that commented included Mr. Retief Manel, who also notified us that he would love to join, but he's currently experiencing load shedding. He will join in due course. Then there's Miss, I don't know if I pronounce it correctly, Martijn Swart from the Rooibos Council, Councillor Betsy van Noordwijk from Hessequa Municipality, and Miss Ingrid Woodrow, who is from the Association for Food Science and Technology. And then we also have from the public, Miss Kayleen Marhota, Specialized Environmental Officer. I'm not sure if she's from the public or whether she she represents the department. I think she might be representing the department. Perhaps if I could ask Ms. Marhuta, if you could introduce yourself, then Ms. Woodrow and the others may follow on that.
Good afternoon, Chair. I'm Kayleen Mahota. I'm from the Western Cape Department of Environmental Affairs and Development Planning. I'm just attending as an observer because the department didn't raise any concerns. So we're just here as an observer, and we have a representative from Cape Nature that will take the lead if there is any concerns or comments to be answered from the Western Cape side.
Thank you very much, and we'll get to Mr. Dion Rousseau a little bit later. Ms. Woodrow.
Hi, yes, I'm Ingrid Woodrow. I sort of joined SAFOS last year as the CEO, and obviously all the different things pertaining to food have a lot to do with us, and that's why I'm very happy that I was invited. Thank you.
You're most welcome, and please, you're welcome to make notes should you wish to make a few short comments after you've heard what the national departments have had to share with us. Good. Can I then ask, I've already mentioned the name of Mr. Dion Rousseau, and the others can follow up after him.
Good afternoon, Chairperson. Dion Rousseau, representing Cape Nature.
You're most welcome. Mr. Gafoor and others.
Good afternoon, everyone. Anwar Gafoor from the Department of Environmental Affairs and Development Planning, just as an observer, a colleague of Kayleen Mahota. Thank you.
Thank you. Then we also have from the Premier's office, I believe.
Good afternoon, Chair and members. My name is Astrid Miller. I'm a State Law Advisor at Legal Services, Department of the Premier, and I will be providing support to the department on any legal technical comments.
Most welcome to you as well, ma'am. Please, any other people that may have joined us? I see Bongiswa Matoti's name.
Good afternoon, Chair. Is Bongiswa Matoti from the Western Cape Department of Agriculture. My national department is here for any other thing, but we are actually here on observer status. Thanks, Chair.
Thank you. Most welcome. I see a number of other names. You can please proceed.
Good afternoon, Chair and colleagues. Name is Winston Smith from the Department of Forestry, Fisheries and Environment, looking at the Veldfire Act. Thank you, Chair.
Glad you could also join us, sir. Other guests?
Good day, Chair. I'm Natasha Visser. I'm a researcher.
Thank you, Ms. Visser. If you're going to participate, please note that your microphone is set at a very soft setting and that you will have to speak up. And then it's also my, yeah, thank you. Other members or other guests actually first who would like to introduce themselves. Good, and then thank you. I see the Honourable Maran seems to also being able to join us somewhat earlier than anticipated. Honourable Maran.
Thanks, Chair, and good afternoon to everyone present. My name is Pat Maran, member of this committee.
Thank you. I'm so glad you could join us. Anybody else that has joined us since? I see Advocate Marstorp and others.
Afternoon, Chairperson and everyone in the meeting. My name is Romeo Marstorp. I'm the legal advisor for Provincial Parliament assigned to this committee for this bill. Thank you, Chair.
Thank you. I do see a number of other names, people that have not introduced themselves. If you would like to, please go ahead. If not, we're going to start with the agenda. Good. Thank you very much then. So let's proceed. As I've said, no apologies except for the Honourable Maran, who has since been able to also join us now. And as I've said, I think it's Nell that indicated that once load shedding ends, he would love to join us as well. Honourable members, please allow me just for the record, or read into the record a little bit of the background to this meeting that we're having today. Today's meeting deals with two bills that have been referred to this committee: the Agricultural Product Standards Amendment Bill, officially numbered as B15B of 2021, and the National Veld and Forest Fire Amendment Bill, B24B, also of 2021, were referred to this committee on the 12th of June 2023. The respective national departments at the time briefed the committee on the content and the impact of the amendment bills on the 20th of June 2023. And then at this meeting, we as a committee resolved that while the two bills deal with different departments, we will advertise them together or concurrently and invite members of the public to respond on either or both of these amendment bills. We also decided to place advertisements in certain newspapers, and the advertisement appeared in the Weekend Argus and the Burger, Saturday's edition. These appeared on the 1st of July 2023. Then we also made use of the social media platforms of the Western Cape Provincial Parliament, and we also put some paid advertisements on places like Instagram, Twitter, and the Parliament's Facebook page. So we then targeted for the Agriculture Product Standards Amendment Bill, retailers, wholesalers, and I'm not going to mention them all, farmers markets, exporters, etc. Quite a long list. And for the National Veld and Forest Fire Amendment Bill, we also paid for a targeted campaign, and there we targeted provincial conservation agencies, fire protection associations, forestry companies, farmers, and environmental consultants. The first campaign reached over 190,000 people, and the Veld and Forest one 185,000 people. Then we also sent letters to alert various institutions and entities to the existence of these bills. These include Agri-Western Cape, the municipalities in the Western Cape, Hortgrow, Westgrow, Grain SA, a number of organized agricultural institutions. I'm not going to mention them all. A number of chambers of commerce, including the Cape Chamber, the Black Business Chamber, the African Farmers Association, etc. Also a number of unions such as COSATU, various universities in the Western Cape, the Consumers Union, and then also the South African Local Government Association, National Biodiversity Institute, Environmental Rights, Timber Growers Association. The list is really long. And the closing date for comments by members of the public was the 24th of July 2023. The comments that we received were then forwarded to the national departments respectively to be able to prepare for today's presentation. I might also add, honourable members, that we also invited people to leave WhatsApp messages on a dedicated WhatsApp line. And the idea was that particularly people who may struggle with reading and writing, and people that may be impaired in various ways, would be able to make use of that. No messages were received on that WhatsApp line. And yeah, so this is where we are today. A matrix of the comments received was prepared by our procedural officer, Ms. Niekerk, and thank you very much for that. And as I've said, those were then forwarded to the national departments, and therefore we've now come to the point where we can ask Mr. Billy Makafola, who has also joined us today, to give the national department's response to these submissions received. And therefore, if it's fine with you, honourable members, I would like to give over to Mr. Billy Makafola. Please, sir, we're in your hands.
Thank you very much, Chairperson. I don't know whether the IT people will certainly be able to do us the honors of reflecting those responses. So I should actually read those responses out for members to hear. I don't know which option are we going to go for, that we should actually have them reflected on the screen or while at the same time going through them.
Just a moment. Can we ask that, Ms. Niekerk? Would it be possible for you perhaps to flight that summary that Mr. Makafela is going to speak to?
I'll flight it, Chairperson, no problem.
Just a moment, Mr. Makafola.
Okay.
Is that the document you want to speak to, Mr. Makafola?
Yes.
Excellent.
Yes.
Excellent.
Okay.
Thank you.
Okay. No, thanks very much, Chairperson. The first questions that we had to deal with was from Mr. Retief Nel. And in the main, his comments or concerns were that they wanted to know what would actually be the use of having a bill if at all it's not going to be obeyed by companies or manufacturers. And he also wanted to know
Mr. Makafola, unfortunately, your voice disappeared.
And the biggest. Can you hear me now?
Mr. Makafola, you unfortunately broke up, and we couldn't hear your full sentence. We did hear you when you read the first sentence there, the first comment by Mr. Nel, but thereafter we were unable to follow you. I hope your signal is good.
I was just giving the actual complaint here, if I may, was in respect of the law not necessarily being applied and the law not necessarily being obeyed and perpetrators not actually held accountable. And that actually talked to the act that was not necessarily the bill that is before you. It actually spoke to the act that has to do with the control of agricultural input, which I've actually set out there. That is the Fertilizer Farm Feeds and Animal Feeds Act 47 of, I think it's Act 47, I don't know where 1972 or something thereabout. But it's not necessarily the act that is actually before us. The act that is before us, the bill that is before us, is the Agricultural Products Standard Amendment Bill, which amongst others sought to deal with the definition of management control system and also provide mechanisms of ensuring that management control systems are actually realized through auditing. So the concerns that Mr. Retief Nel had has got nothing to do with the Agricultural Products Amendment Bill. And in fact, if I may say, the bill itself is, or the act itself, the principal act from which the bill emanates from, is well applied. You would actually recall that we do have assignees in the form of PPCB. We have assignees in the form of PROCON, who are actually, amongst others, in addition to departmental inspectors, who are responsible for the application or enforcement of that act. So in that respect, the concerns that was raised is not necessarily related to the bill that we assist with. So if we are to go to the second question, I think it goes on to highlight the fact that the copper sulfate is toxic and kills livestock and fish. Yet again, the issue that has been raised is not necessarily related to the act. The act is well actually enforced, as I've indicated, that the current application of the act bears out the true situation where assignees such as PPCB, SAMIC, PROCON, Food Safety Agency, and departmental inspectors ensure that, amongst others, South African exports of high quality and safe agricultural products are exported to those international markets. And indeed, the South African producers are sold in our retailers with the assistance of those SIDs and inspectors. So from that point of view, the concerns that has actually been raised, whether it is actually indeed true insofar as Act 36 of 1947 is concerned, cannot necessarily be authenticated. But the matter that we are supposed to be seized with is the bill before us, which at any rate, the act from which this bill emanates from is well enforced. If we can just go to the other question that is also going on about the fact that chlorine was banned and that in the EU and the USA, it's already sanitized water with very treated with chlorine, and it's going on and on. And as I said, those are issues that can best be dealt with under a different legislation than the one that is before us. So that is what I could say in respect of the concerns that were raised by Mr. Nel. When we go to Rooibos Council, that is Ms. Swart, they wanted to know the clarity on the practical implication that this may hold for Rooibos industry. Now, the practical implication is that of management control systems. So there are products that are Rooibos tea in the main, if it is actually produced without the employment, without the use of inorganic fertilizers, that would actually then come handy, because then you'd actually automatically tag such Rooibos produced in such a manner as organic. And if it's organic, it means that it talks to a method of production, and that method of production would actually best be characterized as management control systems, as we have it. So management control system talks to, then you can then use those claims. And once you use those claims, then the assignee appointed will then come in and audit the entire production system to check whether indeed it complies with the regulation that shall have been published at that time. So the implication is that more than anything, it will actually authenticate and give the necessary credence to the production method that shall have been followed in the production of Rooibos, and provided, of course, that there are claims attached to that. If you are going to sell it as organic Rooibos, it means that it has to comply with regulations that defines application insofar as organic production is concerned. So, and the other thing is that they also mentioned the fact that there is PPCB, the role that PPCB plays as an assignee and all of these things. So what we are saying is that over and above the introduction of this bill, that opportunity now exists for them to have that opportunity to participate in the determination of audit fee or inspection fee. So there is a clause that has actually been brought in, which will afford.
Where is the report? I don't see the report of the public participation with this bill.
Can somebody just mute the Honorable Murray, please?
Okay, so that is that. So the implications are that we would actually then have a situation where you have a bill that for the first time would certainly have regulations that speaks to the manner in which things are produced, and the claims thereof will then be authenticated against established regulations. But more than anything, you have an opportunity as Rooibos Council to participate and influence the trajectory insofar as the determination of fees is concerned, whether be it all for auditing purposes or inspection purposes. So that is the actual implication that this bill harbors. Can we go to the next slide? So they also pointed out that in the past, there were biggest challenges in terms of the appointment of assignees that had no knowledge of the industry and were not equipped to audit. But I see that this is now, of course, the bill has addressed that, but even in the previous, the current act as is, the minister still reserves the right to revoke the mandate of those assignees that do not live up to the dictates of the act as it were. So what has happened in the past is that there were 2 assignees, which as a consequence of their non-performance, they were actually revoked. So the minister still has that right, but the current bill also tries to at least drive that point home. So I think I've already spoken to that. The comment from Betsy van Noordwijk, that is the from Democratic Alliance Ward 7 councillor, as a core municipality. Of course, we totally and fully agree with the sentiments or comments expressed that they would like to comment and express their appreciation for the initiation of the Cultural Products Standards Amendment Bill, since it is crucial to maintain high standards in agricultural product to ensure quality and safety of product. And this bill also highlights the importance of such standards, but also aims to enhance and update the existing regulation in this regard. Of course, that is the actual intention behind this bill. So that much we agree and fully concur. From the Western Cape, there was a from Western Cape Department of Agriculture, there was a proposed definition that was advanced in respect of auditing, which seems to have elements of the previous definitions that we had in the bill that was introduced before Parliament. And it has since undergone some serious changes in terms of refinement, where the essence of what audit is has not been lost. The fact that it's systematic, and it may not necessarily be there, systematic and functionally independent examination of management control system, and the definition that we currently have, which is pretty much different from the one that has been proposed, because the one that is proposed by the Department of Agriculture seems to be going back to the definition that we had. So what we actually did was to dispense with certain words, such as your systematic and functionally independent examination of management control system. That's what we have. Examination of management control system in order to determine whether activities and related results comply with the claims associated with the product. So what it essentially means is that your independence is still going to be there, because what we are saying is that the assignee that is supposed to be undertaking auditing itself as an institution has to be free of conflict of interest. They don't have to have any interest, pecuniary or otherwise, in the product itself. But equally, audit itself has to be independent. And it is going to be systematic because it's going to be deriving from a regulation that would actually be applied. So some of these things that have actually been included in the definition that has been proposed will certainly be captured in the regulations that is going to be developed for each and every management control system that we're going to be having, specifically those that attaches to claims that are linked to the product during the sale or export or import of such product. So the definition as we have it does not necessarily differ much from what has been proposed, except to say that that was the initial specifically from the first one, systematic and functional. It was what we proposed before, but through refinement and through the first hearing that we had with different stakeholders, it was felt that the definition it can actually be much more better read if it is actually amended to the current definition as we have it in the bill. And of course, the language that has actually been used of the scheme is not something that is the scheme in this sense. It has to be right to be management control system, which essentially is method of production. So the manner in which you're going to produce the product is what we characterize as management control system. So if you read that definition of management control system, it tells you precisely that it is essentially at the base of it, the manner in which the product has been produced. So we don't deal with schemes here. The scheme and the manuals, your manuals in this case will certainly be your regulations. And what essentially you have in mind as a concept of scheme will certainly be a management control system. So all of that is actually captured there. So if we go to the second proposal from where they wanted to add a subparagraph that says that having particular knowledge as to confirm by providing confirmation through the review of objective evidence that requirements have been met. We say that that is a bit, it may actually be redundant in the sense that when you designate an assignee, you designate assignee on the basis of the qualifications that shall have been presented. You shall have also attestations that are given to you that talks to the fact that they are free of any influence. They are not conflicted in any way. So that will certainly be in a documentary form. And for you to be able to appoint them, there must be some due diligence that are taken to ensure that indeed the information that is put before you is correct. And that is a once-off process. So once you've appointed, you would not be able to go to this. You would not be able to say that, because we already say that they must be having particular knowledge, of course. And that knowledge, the attestation to the fact that they do have knowledge will certainly come in the form of relevant qualifications to just to prove that indeed they will certainly be able to have the qualification. The CVs and all of this will certainly be part of what will certainly constitute and guide in the designation of such assignee. So the point that has actually been suggested will certainly not serve any purpose whatsoever, because implicitly that is already been done. When you have applications before you, you check for their authenticity and all of these things. So there's no need for you to have that. So that is our response. So, Chairperson, that would be our response from the department.
Thank you, Mr. Makufela. Can I just ask first to the honourable members, are there any one of you that would like to ask a question or comment on the presentation that we've just had?
Yes, sir, certainly would.
Please proceed, Honourable Murray.
Sir, I'm a bit concerned that you are too lackadaisical in addressing the objections of the Western Cape government. You know that the Western Cape government's officials are the best in this country, and we govern the best. It's been proven. You can't just wipe it away. To say that having particular knowledge as to confirm by providing confirmation, and your answer is basically that the proposal of the Western Cape runs the risk of being redundant. How can it be redundant if inadequacy and not being able to deliver is one of the hallmarks of South African failures? The regulations is weak law. You mentioned here the minister must pass a regulation, but a regulation passes parliament scrutiny. You should know that. A regulation is the minister taking over the power of government. He's been given carte blanche to do what they like with the regulation. So I think we should certainly, I will not support this response given to both 9 and 10, because in order to audit something, you need an independent auditors. And this is exactly what the Western Cape has said. They need independent auditing, not auditing by compromised individuals. If that was the case, that auditing was well, our municipalities, for instance, wouldn't all be in trouble after auditing. I think that they must have a new look, and I would like you to tell me, how can you justify saying that our proposals is redundant if what we call for is having particular knowledge by providing confirmation through the review of objective evidence that requirements have been made? That is something that should have received far more attention by the National Department than what the response is here. Because one of the requirements also nationally is that you must get the right points in order that equity is achieved between races. Some races get 2 points if you're a doctor with the same qualifications. You nevertheless get more points if you're a certain color, and no points if you're white. So how is that then requisite qualifications, conflict of interest, and all those addressed? I don't buy that. I will never buy that. Thanks.
Thank you,
The
Honourable
best
Marie.
government for who?
Can I just, Honourable Maran, please, you know the rules for our online meetings. Please, no interjections. You're welcome to raise your hand if you want to comment. Honourable Marie, you're next.
Thank you, Chair. Chair, my interest was piqued particularly with the comments from the rooibos industry. I wonder if we can just scroll back to that. Thank you very much. My interest was piqued because I recalled that the rooibos industry was awarded PDO status last year. So place of designation, origin, something like that, last year. And effectively that gave it a set of rights to be recognized as, for example, champagne is within Europe. And that also aims to bolster economic activity and to bolster this important rooibos sector. I know that, for example, our local Department of Agriculture is looking at other areas that could also get PDO status, like lamb or snook, for example. And I wonder how some of the measures suggested might impact or undermine efforts to implement PDO, but starting particularly with rooibos because they have just got this designation. Thank you.
Thank you. I do recognize the Honourable Maran.
Thanks, Chairperson. My apologies for interjecting. I was just asking the Honourable Marais when he said the Western Cape government is the best in the country, and I was asking the best for who? Chair, in terms of the responses from the department sides, I'm quite happy so far. It's only, I think it was point 2, where allegations was made. It's 2. Yeah, allegations was made by Mr. Retief, mentioning the names of certain institutions like Line Veterinary, Biofarm, etc., Chair, making serious allegations that these companies are using illegal stuff that basically poisoned livestock, fish, etc. Chair, my concern, Chair, is just that the allegation that's been made, and the which Chair also want to check which is privy to this information, and whether allegations made against those, whether they, Chair, when they get out of this information, taking this particular person further. Chair, I'm just worried about that particular issue, making serious allegations when it comes to certain companies. Thanks.
Thank you. Thank you very much. Can I just add to those questions, Mr. Makafola? We already know that there are certain standards, such as, for example, applied by religious organizations, such as the Muslim Council, where certain food would be typified as, say, for example, halal food. What is the relationship then between the signees by the department and the councils that, for example, control certain standards which are linked to religious standards? That's my first question. The second one is I see that the initial bill, the main act, refers to, when it speaks to the products that is covered by this, that it could be any animal or even of a vegetable or any commodity or something produced from a substance of vegetable or animal origin. And the Honourable Murray already referred, for example, to snook, for example. Now, I do know that in our interactions with the abalone farmers, that they have expressed concerns about quality standards. For example, when confiscated abalone is being sold and there's no tracing of the origin of that abalone, which obviously eventually is also something which is consumed by consumers and which could even lead to consumers being poisoned or having adverse effects. How do industries go about to ensure that they have an assigned person and that certain standards would be developed for products to be adhering those standards? And is that covered in either the original bill or the amendment bill, as I don't quite see that? Over to you, Mr. Makafola.
Thank you very much, Chairperson. Let me start by responding to Honorable Mare. I do not recall in my submission or my answering insinuating any incompetence or competence on part of the Western Cape. Redundancy means exactly that. That if something is superfluous to requirements, it is redundant. And it has to be understood within that context. The context from which it was extrapolated by the Honorable Mare is unfortunate. It's not necessarily what I said. And I cannot necessarily agree to his comments that I've actually said anything about Western Cape being governed differently from other provinces. I've not said any of those things. I was merely responding to. And let me tell you, let me show you as to where do I come from in terms of that approach. The section that we were referring to talks about designation of assignees. Now, when you look at the designation of assignees, there is qualifications to that effect. It is section 2 that was introduced, and it is actually saying exactly what he was saying. It's safe to say that possibly he might not have actually had sight of what the bill is all about. It says the minister may, for the purposes of this application of the act or certain provision thereof, with regard to a particular product, designate a person, undertaking, body or institution, association or board, having a particular knowledge of the product concerned, having a particular knowledge of the relevant control system, and with no direct or indirect personal or financial interest. So it's exactly what Honorable Mare was actually trying to drive home. It is actually covered there. So if you are to add what has actually been proposed by Western Cape, it is going to be superfluous to what has already been it's actually contained in there. What they are proposing is already covered there. So if you are to bring that into account, it will certainly be superfluous. So it then renders the whole thing redundant. That is of course, that is English. It may not necessarily be my first language, but I understand precisely it means exactly that. It has got nothing to do with the capability of a particular government or any person. I've not actually brought any of those allegations that were intimated to me whatsoever. So in respect to the question that was raised by Mare, by the, I think it was Ms. Swart, or I don't know. It was in terms of the PDO, that the changes or the amendment bill has got nothing to do with those. You would recall that we have our geographical indication regulations. So they would actually fall under 6A. So that is still fine. And your PDO was actually established in terms of Merchandise Marks Act, which is still fine. But of course, we do have what we call, we are busy now with the Karoo in terms of Karoo lamb, in terms of the our new regulations, where we are on the cusp of conferring that status. Of course, we still have to traverse certain routes first before we finally confer the GI status to the Karoo lamb. So it will actually fall within those. But as it is now, it doesn't affect your status whatsoever in that respect. And of course, I note the comments that have been made by Mr. Marang. Of course, in terms of halal, Chairperson, if I may, the standards, the method of production, like I indicated last time, that the standards regarding halal, which is a method of production, is also going to be something that is going to be affected by this introduction. We've had discussions with the Western Cape Department when this thing was first mooted. And we actually say that we have to be very circumspect because of the constitutional rights that actually borders on religious beliefs. So when we say that the people who are to be appointed should have the necessary, the requisite knowledge, it actually means that you have to tread very carefully in that respect. Liaise with those councils so that when you come up with, ultimately, if ever you're going to designate a particular council or a group of people formed from different councils, to actually take care and ensure that halal itself as a method of production, as a management control system, is actually audited, not necessarily detracting from their ways of doing things. So it is something that will certainly going to be affected, but we will have to be very, very, very careful in terms of how we address that one. And for snook and abalone, those are marine products. They do not necessarily fall within the scope of the Agricultural Products Standard Act. So there would certainly be the National Regulator for Compulsory Specification under the Department of Trade and Industry and Competition. That would certainly take care of that. Thank you, Chairperson.
Thank you very much, Mr. Makafola. I do not see any of those that responded to call for comments on the online currently. If there are, please correct me. Can I just ask, are there any comments, for example, from the Provincial Department or from the Western Cape Provincial Parliament's legal advisor who want to raise items which you believe the committee should take into account? I do not see any other hands but that of the Honourable Murray. Back to you, Honourable Murray.
Thank you so much, Chair. The point, I listened to what the Honourable Gentleman has just said, Mr. Makafola, and I accept his explanation. What bothers me is on the Western Cape Government's question 10. Now, in response, the department says whether the assignee in question qualifies for designation or not. Now, that word designation comes through in the Labour Equity Bill. It says these are the designated people that qualifies. And then it says you must be African, you must be coloured or Indian. That is the designated group who must be affirmed at the expense of whatever other qualifications other races might have. That's the designation group that must be affirmed. Now, your explanation on question 10, it will be the guiding factor in determining or confirming the suitability of whether a assignee in question qualifies for designation or not. That bothers me. Can you explain what does it mean? Does that designation refer to the Labour Equity Law, which speak of a designated group of South Africans who will come in line for preferential appointees?
That is the question. Mr. Makafola, would you like to comment?
Yes, look, I think, well, the designation as we have it here is very much circumscribed. It simply means appointment by the minister. So that appointment, the criteria against which that appointment is to be effected is well set out in the Act. It has got nothing to do with what is actually prescribed in other legislations. But in the context of the APS Act, you would have to look at somebody with a particular knowledge of the product, and such a person who has relevant management control systems, knowledge thereof, and such a person should not necessarily be having vested interest. In other words, should not be having any conflict of interest, whether personal or or financial. So in the product itself. So those are the two guiding criteria that are referred to. So designations in the context of the APS Act means the manner in which those assignees, and in most cases are juristic companies. So it may not necessarily be something that, well, if it does have something to do with other imperatives that are included, are housed or harbored in other legislation, it's something that in the context of what we have before us, it is exactly in terms of the knowledge of the product itself, the knowledge of management control system, and the fact that you have to be free from any conflict of interest.
Thank you very much, Mr. Makafola. If I read it correctly, the concern is that the assignee, which could be on any individual or institution that needs to guard, if I can call it like that, over the agricultural standards, that person must have the necessary knowledge of the product to be able to, can I call it, manage the standard of that agricultural product. And it seems to me as if you go back to the Rooibos Council's concerns, that they have actually said that in the past, unfortunately, their experience has been that people sometimes had to guard over standards without having the necessary, can I call it, the technical knowledge of the product in question. And you say you are trying to address that, although the Western Cape Department of Agriculture believes that it should be stated quite explicitly in the amendment bill. Am I correct in summarizing that?
No, I think they started that best. Let's just take the practical reality that obtains today in terms of those assignees. We all have juristic assignees, not necessarily natural persons that have been appointed. We do have PPCB. It's already there that is a byproduct of this very legislation that is actually enforcing and applying the law for all exported product under the scope of this act. We do have SAMIC, which is responsible for red meat inspections. We do have Food Safety Agency, which is responsible for processed meat, eggs, and poultry. Those are juristic company. So essentially, though the act, the bill as it is, or the act as it was, still permitted that you may, in some instances, appoint a natural person or a juristic person for that matter. The guiding criteria would certainly still stands that you'd have to have the requisite knowledge of the product of management control system, and you do not have to be conflicted. Those are the three principles against which an appointment or designation will certainly be effected.
Good, thank you very much. Any further questions to Mr. Makafola? I do notice the hand of the Honourable America.
Thank you, Chairperson. Chairperson, in relation to comment number 7 regarding the agency fees for the Rooibos Council, fees of assignees. Can Mr. Makafola just elaborate a little more in terms of how this amendment will contribute to transparency in determination of the fees, and how different is it from the sort of existing legislation, and to what extent will stakeholders and what is regarded as stakeholders within the industry be afforded an opportunity to participate in the determination of those fees. Thank you, Chair.
Thank you, Honourable America. And perhaps Ms. Niekerk, I don't know how quickly it would be for you to bring up the amendment bill, section 3, or the part that deals with section 3 particularly. I believe that might be of interest to members, and also address some of the concerns which we've heard not only today but also previously from industry role players that are concerned that we need to manage the price of food carefully and not add to the cost of producers unnecessarily. Over to you, Honourable Marais.
Thank you, Chairperson. I just want to ask, there are new entries to the rooibos industry. And that comes from the previously disadvantaged groups, mainly people referred to as coloured. Now, I know that under 6, had with the Chinese rooibos tree industry had challenges with assignees is that they had no knowledge of the industry and were not equipped to audit rooibos. That can be said true of them. That is why to get certification of their product is a problem. They must market their products overseas. And because I don't think they know the process to get certification for quality. You only made a comment there, noted. Why? What is your answer there? Because this is a problem. With the rooibos industry, I know the Griqua people, they only receive royalties from the sale of rooibos because they themselves do not cultivate rooibos. But there are small rooibos farmers in our community. The certification process of their products so that they can find overseas markets. Is that something your only comment will be noted? Or who will be assigned to make sure of the quality of the type of rooibos tea which they can produce? Just wanted to know, because noted seems strange. All the others has been responded to except question 6. Thank you.
Thank you, Honourable Marais, and thank you to Ms. Niekerk for beaming that onto our screens. Ms. Niekerk, I don't know if the text could be increased in size. I see there at the bottom right-hand side, there may be an icon that can help to increase. There you have it. Thank you very much. Mr. Makofelo, I presume this is the section that you would like to speak to when it comes to addressing the concerns of the fees and how the fees will be determined.
Oh yes, Chairperson. In fact, thanks very much. I'm completely indebted to you for bringing that to the fore. This actually set out the basis or the trajectory that will certainly be exhausted in terms of seeing to it that the transparency setting of fees. Of course, this process actually also obtains insofar as the administration of budget is concerned. But what we did was to, just for emphasis, bring it into the bill here. What we are saying is that there has, within a certain period of time, there must be a business plan and a budget submitted to us, to the assignee, coming from the assignee, proposing as to how their inspection or auditing fees are going to be. And along with that, you'll actually have to see all the cost drivers and all of those things within the budget. And that will certainly be given for us for considerations. And then what we'll then do as executive officer, within a certain period of time, we will then open it up through government gazette, publish it there, invite comments for people to comment on the business plan itself, the budget itself, and indeed the proposed inspection fee. And then we will then consider all of those comments, process them, and then respond back to the proposer of the set fee and the budget, of which is the other side in this case, to say that, look, your proposed fees are accepted in the main by the affected stakeholders, or they are not accepted based on the following reasons. That is the only way that we can actually bring transparency and for people to have a say in the current determination of fees. Because as it is now, we know that we do have inspection fees and auditing fees are determined by the board members, and not all of those the board members are representative of the product that are inspected or audited. So that would certainly give all the other stakeholders an opportunity to have a say in how the the fees or inspection fee or auditing fees are going to be set. That is the section that I wanted to bring. That is the section that I think responds to the Honorable Americas. With respect to the noted one, noted means concur. What you are actually indicating there, what a rooibos industry is bringing to the fore is exactly that. It actually runs counter to the allegations made, in that there is PPCB, and PPCB is the assignee under the Agricultural Products Act that sees to it that product, it has the requisite knowledge, that sees to it the product exported to those areas. And in fact, to export is much more strenuous because you have to actually comply with international standards. Some of these standards are very, very, very strict. So the mere fact that we are able to export to international markets means that there is a level of credence that one can actually give to the competence that our assignees have. Thank you.
Good. Thank you very much, Mr. Makafelo. Honourable members, there will be an opportunity for us to deliberate on the question and answer session as we draft our mandate to our representatives in the NCOP. And if it's in order with you, I would like us to consider that just after we've had the presentation on the National Veld and Forest Fire Amendment Bill. I do not see any further hands at this point in time. So if that is fine with the honourable members, I'm going to allow Mr. Makafelo and his those that were mostly interested in the Agricultural Product Standards Amendment Bill to exit the meeting now. And I would like to welcome those that are interested in the National Veld and Forest Fire Amendment Bill. Thank you very much, Mr. Smith, for your patience. I do note the Honourable Murray's hand. Do you want to say something before we continue to the Veld and Forest Fire?
Yes, thank you, Chair. I agree on your way forward. I just want to, on behalf of you, Chair, with your indulgence and the committee, sincerely thank Mr. Makafolo for the very comprehensive feedback that he provided. We can see that he is very vested in this and takes the matter very seriously, and we appreciate the hardworking officials such as himself for their efforts. Thank you, Chair.
Thank you so much. You've taken the words out of my mouth, and I think you spoke on behalf of all the members of this committee. Thank you very much, Honourable Murray, and from our side, Mr. Makafelo. I know this is not the end of the debate and the process, so thank you very much for what you've done and also for what you are going to do going forward. I think it's the one thing that we can emphasize is that agricultural product standards is a very important topic, that the public must know what they pay for when they buy or what they consume, if they consume products which claim to be organic or claim to be, hormone-free, etc. So thank you very much for your work and everything of the best for the further debates where you will be involved with probably in the NCOP when the delegates deliberate on the input from the various provinces. So thank you very much and have a great day. And with that, I would like to welcome Mr. Winston Smith. Can you please, are you going to flight something as well, Mr. Smith? The Honourable Maran, can we please put you on mute? Mr. Smith, is there a presentation from your side as well?
Good afternoon, Chair, and good afternoon, honourable members. We've sent a reply through to the legislature. So if I believe Shireen is in the meeting, if she can share the Word document. If not, then I can try to look for the document on my side.
There's no doubt in my mind that Ms. Niekerk is the best one to flight that for us. Her filing is excellent. So, Mr. Smith, there you will see it.
Yeah.
And please speak to that then.
Yeah. Thank you, Chair. Thank you, honourable members. I actually found the debate on the previous bill quite interesting because it's also affecting all of us as consumers. And so it's always good to see the other side of the work of the standing committee. I'm going to talk about the National Forest Fire Amendment Bill, and the chair gave quite a good overview of the process followed, which I'm actually quite impressed with. And I will then respond to the questions received. I believe we received questions from the Western Cape and Issaquah and the like. If one look at the first comment, it is grammar, and we appreciate that that grammar issues are being taken up and picked up. So the word matter and should be matters, we accept that as not as correct. The next one is clause 2B, definition of municipality, where we refer to the Municipal System Act. It's actually the Systems Act. We cross-reference, and that is also then correct. If one then go into the meat of the other comments, is the first one is amendment of section 3 of the Principal Act, where this clause seeks to empower the municipality to facilitate the formation of a FPA. And the question is what the word facilitation means. I think one have to read this amendment with the Principal Act and the regulations. And under the Principal Act, it gives you the role of the Fire Protection Association, and then also state it must be registered by the minister. And then the minister then, in her wisdom or his wisdom at that time, then put out regulations to give you the detail of how an FPA should be formed. So that formulation is the municipality and also additional councils can start the process. And when they start the process of facilitation, obviously then the department will be involved and guide them. So it's just giving them that ability to start talking about fire associations. Then the next one is, the question is, unclear why municipalities and traditional leaders may facilitate. The response there is that maybe in terms of municipalities, it can be unclear, because I'm just looking at, for example, a situation in, like, you've got the Stellenbosch municipality and they want to form a FPA, but you got your Winelands FPA, and that may work and may not work, and it is going to be a long process. So there may not be a need for that, but it offers them the opportunity. But in terms of traditional leaders and councils, I must admit, there is large tracts of the country that's under traditional leaders' ownership, and this act and the amendment apply to all owners of land. And currently what we found is that large tracts of land, there's no fire protection association. Fires are raging. Currently, as I'm speaking, the Northwest is burning at an alarming rate. We're losing thousands of hectares each day. It's predominantly traditional land. There's no FPA being formed. The Act referred to this, the Nkanyama Trust. They've got almost 3 million hectares. So it will enable those traditional leaders and municipalities, if need be, to form an FPA, so that the essence of this act is to prevent veld fires, and then how do you combat it? And that is what this amendment seeks to achieve, is to how can we prevent veld fires in the rural areas, the situation that we currently have in the Northwest. What can we do? So that amendment is just to get a bigger reach to all landowners in the country. Mr. Nika, just go down one slide again. So, and then I just must see, I think I covered that. The next one is also from the Western Cape government, as a space should be inserted before the word established. That's accepted. The next one is it's referring to join a fire protection association. Although I said accepted, I must just reiterate, it must be actually a registered FPAs. We already FPAs are registered with the minister, but that is in this instance it's been removed from the act, so that is acceptable. The next one, clause 4, section 3, dealing with the principal act that owners may form an association. The question there is, the clause should explain what the position should be if the FPA is resident in an area within 1 year from the commencement of the act. Would parties then need to join the FPA within a certain period? FPAs are definitely voluntary, and one cannot force people to join us. I think it's against the Constitution. So it's a voluntary organization, and if people don't join the FPA, this act has got 2 legs which it stands on. The one leg is all landowners outside the city, town and industrial area, where it's currently in the veld, the forest or mountain area. You can either join the FPA or you act as a landowner. If you act as a landowner, you've still got responsibilities under this act. You have, for example, have to make fire breaks, you have to have trained staff, you have to have equipment, and you have to prevent a fire spreading. Want to spread from your area, you need to interact. So that is your minimum requirement. The FPA is basically just putting lots of resources together, lots of people together, where they share the resources and they share the expertise. So the discretionary case of may form an association, it is to ensure that we comply with the Constitution. But what I have to add is we already got 217 FPAs currently in the country, and what we're actually now promoting is to have bigger FPAs rather than smaller ones. And the model where we are going to and promoting in the department is what I call the Western Cape model, where you've only got 5 FPAs, quite big ones, and they're effective. While a place like the Free State, you've got 44 FPAs, and it's just chaos managing them. There was a comment on in the area in which the land is situated. What FPA boundary is, in most instances, people will follow the municipal boundaries, natural boundaries that they can pick up, mountains, rivers, and the like. But what I actually promote is that, and that's why one cannot be too specific saying this is this area of an FPA. It basically has been guided by a couple of principles under Section 3.2 A to D of the Principal Act. The area must have regular fires. So that you use when you start your FPA, you look at that first starting point. And then you look at, is the risk quite uniform of veld fires? And is the climatic conditions quite uniform? And the forest and vegetation type, is that uniform? That can give you a boundary. And that is basically being used, if one look at the Southern Cape, for example. The Southern Cape is the biggest FPA in the country, and it actually straddles into the Eastern Cape because of the uniformity in that area of the fynbos. So the area, we cannot be too specific in terms of what an area is, because we are, as we say in broad terms, is fire got no boundaries. But fire's boundaries basically determined by geography, vegetation, and that is what we try to achieve in the Act. Another comment there is just going down is 21 to be replaced by 23, which we accept. The next one the Western Cape brought about is that also that we just the word department, but we just correct that, which we are grateful for. Thanks. The Western Cape government then look at clause 7, the amendment of section 26, which indicate that we have to remove reference to traditional leaders. And as I indicated earlier, is that the law applies to all traditional leaders in most instances in provinces like the Eastern Cape, large tracts of land, and one cannot exclude them. And what traditional leaders actually also bring to the table is traditional knowledge, which is quite a bit of them has been lost over the years, especially when it comes to fire. So we want to strengthen the prevention of fires in the rural area, and traditional leaders play a significant role in that. And for that reason, we need to bring them on board. And as I already mentioned, is Nkuyama Trust owning 2.8 million hectares, and that is quite a big piece of land. And then 26(2)(b), that refers to a fire protection officer that can enforce the Act 26, 27, and 28, where you've got your powers to search, seize, arrest. And the proposal is take it away from traditional leaders. What I must just stop and say that is currently under the Act, what's happening is that the Act is currently being enforced by the police, forest officers, and an FPA can appoint a fire protection officer. Now, the department is training a normal citizen in becoming a fire protection officer. And at this stage, nobody's got any complaint. If anybody is, and there's quite a number of them, we just trained almost 30 last year, that is enforcing the Act. And so we've done the training, we provide credit training, and the amendments make provision that if those people are found, the traditional leader, for example, is found to be competent and they carry the card, they can enforce the Act. That is being done since the Principal Act has been in place. We just now give that opportunity to traditional leaders also to enforce the Act, just as the fire protection officer is doing in the Western Cape, in the Cedarburg, doing it in Southern Cape FPA, Winelands FPA, where there is a fire protection officer. So, in the same training that officer is having in the Cedarburg, the traditional leader will have. But what I must just add is that the course is not just given to anybody. You have to be vetted because you are working and dealing under Criminal Procedures Act. So the police will vet the individual, make sure there's no criminal records and all that, and then the person will then go on a 2-week course, quite a tough course, and if that person then pass, it becomes a FPO. So it will just by having, instead of only having a forest officer and a peace officer and a fire protection officer, we now got a much bigger scope by adding traditionals to ensure that we do enforce the Act. Can go down, please. So the powers then, once that traditional leader, like the police officer and the like, have the qualifications that will be specific to this Act, specific to Section 27, 28, and 29. Nothing else. Traditional leader will not be able to enforce other laws because he or she hasn't been trained. In terms of the Western Cape, the next one is that it's recommended that Section 12 of the Act be amended to allow landowners to agree on preparation of a single fire break. What I say is already currently in the Act, Section 15, which make provision for exemption. We, for example, are going on Monday to the Cedarburg to look at exemptions. Last year, we gave quite a number of farmers exemption. So the Act make provision, you can have one big fire break around a big area, or you can still have your individual breaks. But that is where you got your FPA coming in and advising and assisting the minister and making the decision. And obviously, officials will go in that regard. And for example, last year, I've personally have done quite a number of exemptions, even there in the Simonstown area where you've got you've got in Glencairn, you've got all the lovely fire breaks, and one can then look at is it mitigating? Will it not have a negative impact on fires? So that provision is already in the Act, and not many landowners make use of this portion of the Act, and we actually promote it with FPAs and our colleagues to promote the use of the Section 15. Just going down. Fire breaks. The main purpose of a fire break is basically that it must be, first of all, it must have no material that can flammable material. And there is fire breaks. I try to count. There's quite a number of fire breaks. It can be anything from the sea, a dam, a river, plowed land, and the like. So to give more specifics on what is required in a fire break, it is quite difficult. It's almost how long is a string. So what we promote is just have a fire break. It's guaranteed will stop the fire. And I know as being in the fire environment for a long time, like the fires we've got in the Northwest, there's no ways that it will always stop a fire break. I've seen fire breaks of 100 meters wide and fire will run, but that is just the prevention part. So the idea is that you can contain the fire while the local municipality with the resources can come in to stop the fire. So fire breaks, wherever we go, is most of the time people say a rule of thumb is most people just use the 5 meter in it. And for that, and the critical one is going back is that's if you belong to a fire protection association, they will have expertise and they will guide you on the width of fire breaks, types of fire breaks, whether you use your road and your road around your farm or your plot or whatever as a method of fire break. And that's the beauty of belonging to the FPA, because they know the area. Can we go down, please? Yeah, I think that the ESICWA item is very similar to what I just explained about fire breaks, and it is no clear. One cannot have clear guidelines on that because of the purpose of it. And maybe one of the other purposes fire breaks are also used is to fight fires. To use that area as a staging area where you can fight your fires with. But at the end, each landowner should have a fire break around this area to protect himself and herself from fire spreading in or out of this property. And FPA will give you that guidance in that regard. The next one, the municipality, Mr. Puren, supports inclusion of peace officers in the Provincial Amendment Bill, and that is also accepted. Chair, I went quite quickly through it. I'll hand back to you for questions and for clarity. Thank you, Chair.
Thank you, Mr. Smith, and thank you for the work that you are doing, also for this presentation. I think with so many fires, particularly in the Northern Hemisphere currently raging, I think we all have taken a close interest in the subject. Honourable members, if there are any questions, any inputs, please indicate by raising your hands. And I recognise the Honourable Derek America.
Thank you, Chairperson, and thank you, Mr. Smith. I think that the philosophy behind these amendments are quite laudable in the sense that it has as an objective to minimize fires and to deal with fires as expeditiously as possible. My concern I have, Chairperson, not concern, clarity that I need would be one, in terms of the traditional leaders and municipalities. The Act states that where there is a municipality that has what you call it, the FDA, and then that municipality automatically becomes part of that, and one is being created, etc. There's this cross-pollination. So wouldn't it be perhaps be practical possible? And I think that in terms of the Ngonyama Trust, with its vast tracts of land, it may not be possible that these traditional leaders would then form part of the what do you call that, the FDAs that may exist within the districts. And if a new FDA is established, what would be the relationship and the role of these newly established associations with the district municipalities who currently, as we know it in the Western Cape, fulfill that function? And secondly, who would bear the cost that may be incurred by these FDAs? And I know the Act states that government may provide loans and grants to these FDAs and all to individual landowners that may incur costs in dealing with fires. How that will the specific regulations be brought out that will sort of explain that more clearly to the affected parties? And furthermore, Chairperson, I have a concern, I don't know if a concern, perhaps a question in terms of the enforcement agents that will be who have been trained and exist, that being the fire protection officers. And the Act says that where an FDA already exists within a municipality, and the chief fire officer is the designated fire protection officer, and where new ones is being created, then it needs to be sort of established or designated who that particular person may be. And Mr. Smith shared with us that at least 40 of those individuals have been trained already. Be it as it may, Chairperson, in terms of some of the powers that I have a concern with, and namely that the power to search and seize without a warrant of arrest. And I think that even police officers, as we know it to be, do not have that power of search and seizure. They need to get that from a magistrate or a judge, whatever the case may be. And why is there that this Act makes that distinction, that provides peace officers that is being recruited from these FDAs to have such enormous powers, and that to enter premises and seize whatever they deem to be incriminating evidence, so to speak, without warrant. Furthermore, Chairperson, in terms of the Act is absent in terms of the power of arrest. And I may have missed it, but Mr. Smith will just clear that up for me. Although they have that sort of that enormous power of search and seizure without arrest, and the assumption is made but that if the peace officer is of the belief that a warrant would be granted by a magistrate or a judge for the issuance of a certain Caesar warrant, and he is of the belief that had he obtained that from a magistrate or a judge, it will be undue delay, etc. I just need a little assurance that these not peace of protection officers will not abuse that power to enter premises, to seize whatever they deem to be incriminating, and there's very little recourse for the people who will be the subjects of such certain seizures. And then lastly, Chairperson, in terms of, let me see what I think now, gosh. The question of arrest, there's no sort of power that these protection officers have in terms of arresting subjects. They have to enlist the assistance of the South African police. Thank you, Chairperson.
Thank you, Honourable America. Any other members with questions, etc.? Mr. Smith, then just from my side, and I do know last time the Honourable America tried to explain it to me, but I'm clearly a slow learner. The Principal Act was passed in 1998. That was before the Municipal Systems and the Municipal Structures Acts came into being. And now therefore you had to amend the definition of a municipality, and you are referring to Section 2 of the Municipal Systems Act. Now, I'm afraid, but under the Municipal Systems Act, Section 2, I only read that, a municipality is an organ of state, etc., and it consists of the political structures and the community, and it functions in its area in accordance with the political and other relationships, etc. It doesn't, in Section 2, spell out whether it's what it's become known as the Section B or the Section C municipalities, being sometimes we use the word local municipalities and district municipalities. So again, and you also referred, for example, to Cape Winelands and, for example, Stellenbosch municipality as municipalities that, can I call it, accept responsibility, although their mandates differ. And I know that there's, for example, an agreement between these two municipalities and probably many others as well, as to which fires would the one be attending to and which fires would the other be attending to. Now, if we want a municipality to take the lead in setting up a fire protection association, which municipality must do that? I do not find that is, quite clearly described in this piece of legislation. Perhaps if you could just allay those fears of mine in terms of which one would ultimately be held responsible for taking the lead in this regard. And therefore, over to you, Mr. Smith.
Thank you, Chair. I'll respond to Honourable America's questions, and I think it's quite pertinent questions raised. The first one is the word used, cross-pollination. And if I look at the Fire Protection Association, it is located obviously in a municipality. And the municipality in most instances will have a fire brigade services. And later on in Mr. America's questions, I refer to the Chief Fire officer from the municipality that become then a fire protection officer. So that is where you get your cross-pollination, that they sit jointly, the FPA, bit out of town in the municipality with these resources, and they work then together. And how do we attack and attend field fires? How do we promote the prevention of? So that is where that cross-pollination comes in. I think Honorable America has captured it well, and that is the intention of the act, that all role players must work together. The question raises, if you form a new FPA, a Fire Protection Association, but first of all, look at the current ones. He talked about in Kanyama Trust and the likes. I think of your first prize will be is to see whether you can have your traditional leaders becoming part of the existing Fire Protection Association. And that what we will do is, once this bill has been signed into law, we'll have to go out and advocate the new act. We have to do awareness and see whether awareness on both sides, the existing FPA and also with the traditional leaders, to see whether it's not better to form one bigger FPA. So that is one way in which one can move, and that when you can then form, and if you can do it within a district model, then it will actually help the whole district better. But should the traditional leaders decide to form their own FPA, Fire Protection Association, the department will obviously assist and guide them. And then the question that was raised, and Honorable America referred to Section 7 of the Act, where the minister may form loans and grants and that to assist with existing FPAs. So under that provision of the Act, the new FPAs can then come to the minister. But what's currently happening is that the department is developing that support strategy, the Fire Protection Association support strategy, that was basically based on support to FPAs, and also to capture the Section 7 of the Act, what the minister may provide the loans and other assistance. And it's also talking about assistance to landowners on international borders, where they incur cost over and above what they normally would have experienced if they weren't there. And a classic example there is, if you're a farmer, you're under a landowner, you're under the Lesotho border in that mountainous area, your cost is going to be exorbitant, and that extra cost can then be claimed from the minister. And that strategy is going through the approval processes within the department at that stage. What's currently also happening, and it is now implemented, is that our department, through its environmental programs, appointed a service provider working on fire, Kashuko JV. And in that tender that went out, the department will support Fire Protection Association financially. And that modality is still currently being resolved. And that is basically flowing also from the strategy. So if this new FPA wanted to be formed, and so there is money that's then be available, and the money is currently available in the budget. So that Section 7 is in the Act. It's been there for a significant number of years, but never has neither the department or FPS actually bothered to invoke that clause. But we started that process, and then Honorable Africa also raised the concerns about the powers to seize and to search. And then he asked the question, is there power for arrest? Yes, there's a power of arrest. I'll just refer to that. Is actually in Section 29, Honorable Africa. If you look at Section 29, so there is it. But I'll say the question is and I think it's actually quite well crafted by saying that, will somebody not go in and without the warrant of arrest go in and search and seize and all that? And I think one has to put yourself in the footsteps of a fire protection officer. You've got a wind of 200. Somebody's got a 5 liter of petrol in his hand, and he's starting field fires. By the time you come to, and for example, this is in the Free State, by the time you get to the magistrate, 100,000 hectares is gone. We lose, I think, on average, if a field fire in a Free State is really pumping, you can lose, I believe, 10 soccer fields in a minute. There you got winds excess of 100 kilometers of hour, a fire line of more than 2-3 kilometers. It's just ravaged, and you don't have the luxury of now phoning somebody and do that. So this is specific to, and one have to look at this in the purpose of the act is to prevent veld fires. And why do we want to prevent veld fires? It's livelihoods. A veld fire is devastating. You lose lives, you lose livestock, you lose livelihood. And that is it. We're going to stop the process of a veld fire without having serious damages. We just, for example, saw in the Honorable Chair mention fires. We've got fires in, for example, now in Hawaii. I think they talk about more than 100 people already lost their lives. Spain is burning, France is burning, and their fire is now their fire season, and North America is also burning. And the Western Cape, their fire season is starting here from December. So it's an emergency, and in the training, the officers are being made attentive. You don't just go in because I don't like Mr. X, I'm going to seize. It must be under the veld and fire conditions, so we can prevent the destruction of unwanted fire. So, but I think it's very pertinent that we have that powers. Otherwise, people can start fires nilly-willy. We can do nothing. Considering about 90+% of all fires are started by humans, so one have to stop that fires immediately. And then the chair mentioned that the act was promulgated in 1998. That is correct. It's quite a couple of numbers of years ago, and a couple of new legislation came into being. It's not, for example, decision leaders came in, the municipal acts came in, and the question is, how do one link all of this, all these acts? And I think it's one is if we go back one step is by the Constitution, which basically is the tenets is human rights, and where we have to ensure a safe environment for the citizens for the future. And under that Constitution, it gives make a provision to establish municipalities and also to establish fire brigade services. And then it can delegate, the district can delegate services to the local municipality. So that is the framework in which this fire bill is sitting in the act. And then you got your fire services act, which is currently needs to be amended. That was even drafted in 1987, and its tenets is focused mainly around municipalities, the urban area, but the broader definition of an area under that act means it's the whole area. So the intention then is to bring in the municipality, that section 2 is done to saying is that if we refer to municipalities in this act, at least we can reference where they are coming from. And if the reference is maybe not 100% clear, we can always go back and say maybe it is maybe it's not section 2, but we'll have a look at that. So as soon as you make a reference to a state-owned entity, you have to reference it in your definitions, or which we called interpretations under section. Quickly go under section 2 of the act. So we put the interpretation in municipality, and then we can talk about it in the act. We can talk about SOEs, we refer it into interpretations, and we bring it into the act. And so that is where that municipality of section 2 of the Municipal Structure Act comes in, so we can link it, that we don't end up in court and the learned colleagues will stand up and say, you refer to municipalities, there's no reference in your interpretation. So at the end is we try to link this act and to all other relevant acts. And I think it's what one just may have to add also is that this act is actually not standing alone. There's also PDMC that's also not referred to in this act, but it's got very similar purposes of also prevention. So it's one act, one amendment in a whole soup of other legislation. And at the end, I think the drafters, when they drafted it in 1998, never had the foresight of the local municipality, never had the foresight of the traditional leaders. But as things change, it needs to be brought into the amendment. And this is the third amendment of the act that we are currently dealing with. We had one in 2001, we had 2005, and I believe not far from now we will look at another amendment, because the act, we say the act must be responsive and relevant. So it is constantly being amended. But what the chair raises, we will just look at that section 2. Is it correctly defining what we want? What's the intention of the drafters? Are we referencing the municipality correctly? So, Chair, I will definitely have a look, and as department will have a look at that, and we will then see whether we are within the legislative requirements. Chair, I will stop there. Thanks for your time.
Thank you very much, Mr. Smith. Honourable members, I do not see any hands, so can I go over to our guests? Are there any of those representing institutions, or perhaps even in their private capacity, who would like to make comments after they've heard the responses from the National Department? If so, please indicate by raising your hand. Mr. Rousseau, could I perhaps particularly just ask, no comments from your side, apart from the comments that we've received?
Thank you, Chair. Beside being jealous that Mr. Smith is going to Cedarburg to look at exemptions there, I think all of our comments that we did make, I think have been covered. I think there were concerns around the exemptions that's been covered, as well as reasonable control measures that should be implemented to prevent the spreading of fire. So that has to do with the length and width of the fire breaks. I think that the FPA rules are quite specific there, but I think that it is covered by the Act as well. So I don't really have any other comments other than to thank Mr. Smith for the presentation. I think it was quite thorough and covered most of our issues. Thank you.
Thank you, Mr. Rousseau. Any other comments, honourable members or guests? Anybody that would like to add to the debate? You're welcome to do so at this time. I do not see any hands from guests, only that from the Honourable America. Please proceed.
Thank you, Chairperson. I just want to thank Mr. Smith for clarifying my questions and concerns, and I am hopeful that with the implementation of these recommendations in the new Act, that we will have we will be in a position to deal with wildfires and the prevention of in a more quick and competent way. And lastly, just the payment of these fire protection officers, Chairperson. The Act says that it will be borne by the National Department. I just want confirmation on that, and it wouldn't become an added burden to municipalities, particularly district municipalities. Thank you, Chair.
Thank you. And if I may add, I think also the Western Cape province. I do know that we've got quite a big a budget, and we spend a lot of that budget every year on veld fires, as we are in an area where we've seen an increase in veld fires over the last numbers of years. May I then just add to that comment or request for clarity from Honourable America, Mr. Smith? One of the challenges that we have in the Western Cape is that of alien vegetation, which apparently increase the biomass for fires, and as you know, many of these aliens grow quite a lot faster than our indigenous vegetation. Perhaps just your views on the responsibilities of landowners on that, and perhaps how this may link in with the fire protection associations and this bill that we have currently in front of us, because we do know that unfortunately many landowners are unfortunately they don't have the funds to always eradicate these aliens on their land. And I do know that many of them would love to eradicate the aliens, and they would love some financial support in this regard as well. Perhaps just your views on this, and perhaps how this may be covered by legislation, and particularly this bill. And with that, over to you, Mr. Smith.
Thank you, Chair. Just in response to Honourable America's question about payment, and it's coming from the local fiscus. What we've currently got in the department is we make an amount of money available for fire protection associations, and it's borne by the department. And we obviously go through the normal treasury process, but money is ring-fenced for that. So we're not coming to the FPA, we're not coming to the municipality, so that money is ring-fenced. I think the Chair mentioned that there's quite a healthy budget that the province earmarked for veld fires, and I must admit, lots of other provinces just look at the Western Cape and say, "Oh, if we can just have the similar arrangements and the budget." But I know Fynbos is highly flammable, and what the provincial government is doing is basically preventing loss of life, ecosystems protection, and looking after the environment. It's a unique biome that we've got there, and we need to look after it, not only just for ourselves, but also for future generations. In reference to the alien invasives, or basically it's a projection in the Western Cape, the pine and the gums. As a landowner, obviously you've got the responsibility, and I think that funding is a problem. And the department's got the Working for Water program that is assisting, and has spent significant amount of money on eradicating. But I believe we are just one step behind. It is, I think the Chair mentioned, they grow so fast that you take it out today, then you have to have 2-3 follow-up operations, and if you turn your back, they back. So if there's a need for eradication, this is the door one I have to knock on, is the Department of Forestry, Fisheries, the environmental branch. That is what they are dealing with. And also ANIMA is also addressing another act that is addressing alien invasive is the is a NEMA Act. But something just I just want to step off. Something I want to just leave a thought with the honourable members is that material is a biomass. It's wood and it's fibre. There is a use for it. The same Department of Environmental Affairs spent significant amount of research in utilising of this material. It's an excellent build. If you take those projection, that wattle and that, you feel it, you chop it into pieces, and you mix it with a binder. You can build houses, schools. The houses is waterproof and it's bulletproof. I've seen the test, and it don't burn. I've been at a test where it was tested at the CSIR. Outside in the oven, it was 1,300. Inside the house, it was 28. So there's opportunities, but one had to start looking at, especially if one look at Bedasdorp, there is millions of tons of projection, and also on the Atlanta side. I think it's somewhere, maybe not for this committee, but somewhere we need to, as a collective, start looking at opportunities of using this alien invasive. And I think as soon as there's a value to a resource, people will take it out and will add. But that is, I think that's a debate for another day. But I think it's something that one have to chew on. So whenever I see a projection, I see a wattle, I actually see money, and I see job opportunities. So that is something that we have to work towards, that, because the department has done significant work. And the student at the University of Stellenbosch just got his PhD degree on exactly that, building houses from this material, and the immensely strong material. So, Chair, the alien is also species are also in the same department under the NEMA Act. There's also opportunities that one can. For example, the department built a house in Knysna. And if members of the chair, if the secretariat want to get more detail, I can just indicate where it is, and one can go and visit it. And that house is so beautiful. You can put it anywhere in any environment. It's fireproof and the like, and it's beautiful. So there's, although I talk about fire, I just digress about in terms of this alien invasive, because it's also very close to my heart. But at the end, the removal is the responsible landowner. Government is spending money in addressing it because of the NEMA and the environmental impacts, and also the impact on water and food security. So that's why we need to address and tackle these alien invasives. Thank you, Chair.
Thank you, Mr. Smith, and thank you very much for your responses, also for presenting to us today. Also to our guests for the interest that they've shown, and including those that will be following us on the YouTube channel. We really appreciate your interest in the work of the Western Cape Provincial Parliament. Mr. Marstorp, I noticed your hand being raised and lowered again. Advocate.
Thank you, Chairperson. Yes, it was up, and I thought, let me leave the point, but just for the record, the following 2 points from my side, Chairperson. The first is to thank Mr. Smith also for the input he made. I was particularly interested in his responses to the various comments that were raised, especially those by the department, insofar as the role of or the powers, that is, of fire protection officers is concerned. I'm satisfied that response is a satisfactory one and doesn't raise any other red flags for me. That's the first observation. The other, Chairperson, is really just something that intrigued me when I was preparing my perusals for this bill, and of course, always having the Principal Act as a reference point. I noticed in particular that the Principal Act talks about the purpose of this act is to prevent and combat veld, forest and mountain fires throughout the country. So it's to prevent and combat. I also noticed in the Principal Act, and this is not something that was touched on by the amendment bill, and I might add, is that in instances where there isn't a fire protection association, the minister may in fact recognize a fire control, note the word, a fire control committee as a fire protection association. So I'm pleased that we have Mr. Smith here, and in particular to draw from his enthusiasm and experience in this regard. Maybe just the following. Inasmuch as the purpose is to prevent fires, is to combat fires, is to control fires, why do we have a reference to fire protection officers, fire protection associations, as opposed to fire prevention officers, fire prevention associations. I'm just intrigued by that reference in the Principal Act and it being followed through right through up till today since 1998. My thinking would have been, if I was there in 1998, that to reference an entity or an individual or an association, a juristic association as a fire prevention officer or association or entity, it unlocks other obligations and responsibilities that, for example, just as the Principal Act provides, that even neighbors are encouraged to have one fire break as opposed to two separate fire breaks. So I don't know what is sought to be protected. I do know what is sought to be prevented. And I think it's an unfortunate reference, but clearly something which the department favors, prefers, and uses. I'm intrigued by the reference, by the term. It doesn't help, but it certainly seems to be an established term. That's all from my side, Chairperson.
Thank you. Thank you for that input, Honourable Marsbop. I do not see Mr. Smith's hand. I don't know if you would love to comment on that. Indeed, Mr. Smith. The question is, why do you want to protect the fire and not prevent the fire? You're on mute, Mr. Smith.
Okay, sorry for that, Honourable Chair. The purpose of the Act is, first of all, you try to prevent the fire, and then obviously if it breaks out, you combat it. And in this instance, it still refers to veld, forest, and mountain fires. With a new definition of veld fire, it will just be combat veld fires, because veld fires definition is now expanded to include all vegetation outside the urban edge. And then the Act goes further. It gives you a variety of institutions and methods and practice to achieve the purpose of the Act. The institution, one of the institutions is the Fire Protection Association. Another institution is the Weather Services. Methods is, for example, your fire breaks, and practices is what training you have to do. But if one look at that two purposes, there's actually one word summarizing all of that. It is what we call integrated fire management. It's where you do your prevention, you do your awareness, you do your fuel load reduction, you do your fire breaks, and one of your last activity in the integrated fire management is actually combating the fire. Although in public view, we spend most of our time, most of our effort and time, it seems like it, and it gets the most attention is when you got if Table Mountain is burning, everybody's excited. But in the meanwhile, Cape Nature throughout the year are attending to, through awareness programs, to fire breaks, have the strategic plans in place to attend fires. So the combating is a small part. But something that we sometimes also neglect in the integrated fire management is, for me, one of the major portions is the rehabilitation. And that sometimes just falls away, especially when it's not in nature conservation. So if one then look at that the role of the association is more than just combating veld fires, and that the duties of and responsibilities of the FPA is spelled out there in I think it's section 5 of the Act, and that basically gives you a big. If you read it all this and you engage with what the FPA, first thing they will tell you is it's way too much, that we can't do all of this. We have to, and what they do is, for example, each day they will have to give, in the fire season, inform their members of the danger of fire rating, 3 days warning, and so each day you got your WhatsApp groups flying around. So they got quite a bit of do, because it's in the Act, it's registered. I think so. That's why maybe it's the Fire Protection Association is a word that the drafters of the the Act came in. I think Advocate Master raised quite a interesting point, is that although we mostly focus on FPAs being formed by landowners, the Act actually, when it was drafted, there was quite a number of other associations involved with fires prior to this Act coming into place. This Act was actually part of the National Forest Act of 1986, and with democracy, this was taken out to say fires must stand alone. But you've got fire control committees that can form FPAs, catchment management agencies, forest protection committees, and disaster management agencies. So all those bodies that was there can, and still there, can form it. But over the run of time, the Fire Protection Association became the preferred method of enforcing this Act to prevent, and it's basically driven by landowners that want to protect themselves. And a part of the reason is maybe not so much in the Western Cape, but in quite a number of other provinces. If there's a fire, and I think Northwest, the lack of fire services is alarming, and nobody will respond to a fire, even if it's next to the fire station. Let's just say 20 km away when you're in a rural area. And this fire protection associations, they've got, well, not all of them is well equipped, but there's a couple of bakkies, but sakkies, that people, if there's a fire, everybody jump in their bakkie and they kill the fire, they combat the fire as soon as possible. So the association, Fire Protection Association, never actually, Master actually reminded me that maybe at that time when we drafted the Act, that it was maybe the appropriate name, and we may have to look, maybe not in this draft, this amendment, but next amendment that we have to do. And without giving away my age, Advocate Master, I was around in the department when this Act and the Forest Act of 1998 Act of 1998 was drafted, and I must admit, I was still a youngster these days, and I battled to understand all of these terms. But as I grew older, I understand the purpose of the Act much better now. But I think it's at the end is we want to protect the South African citizen. We want to protect, we want to ensure food security, and we don't want to lose lives and the environment. And what this Act basically does is it places the onus, first of all, on the landowner. Control what you've got in your environment, in your sphere, while we're waiting for more help to come before we dispatch the helicopters, before we dispatch the working on fire teams. So it's very much built on the Ubuntu. I help myself and I help others. And that is, I think, the spirit. But what we maybe as a department fail to achieve is to communicate the Act to our stakeholders and continuously educate. We, for example, spent 2 weeks ago with the magistrates and the prosecutors, but and their request is, please come back every 6 months, don't leave us. So there is a big responsibility on the department to keep on kind of informing and engaging with a platform like this platform that we're dealing with the honourable members, because you also got constituency and you also got members that you of the public that you represent, and by informing you, we all have the more knowledge we have, the more we can inform, the more we can prevent and combat. So the opportunity to share more, we need to use each and every opportunity that we can, and that's why I'm using this opportunity, Chair, to ensure that that first of all, when the amendment is coming through, it's practical, it's enforceable, but issues that Mr. Advocate Master raised, one has to start looking at, are there other things in this Act that we need to change? So this Act obviously goes through another amendment within the next 5 years, and we may, as a committee, be sitting again around this table. Chair, I will stop there and
Yes, thank you. Thank you, Mr. Smith. Mr. Smith, and since you took the liberty of going slightly wider than just addressing the comments on the bill, I want to send you away with three messages, because we don't always have the opportunity to engage with the national government. Firstly, we have found a reluctance from national government to come to our committee in the past. Please, I hope you will take the message back to them that there's nothing to fear. We want to work with you. And please, if we ask you to come and assist us, that there will be a positive response. Unfortunately, in the past, we, in terms of protocol, always include the minister, the national minister in our invitations. And Minister Creasy in the past, unfortunately, declined and indicated that she would not come and meet with us. She believes we've got no oversight role. Granted, we have no oversight, but we are working together as different spheres of government. The second one is we invited your colleagues and the minister to come because you make a healthy contribution to our alien vegetation eradication program. In that particular year, it was about 30 million rand that you made available to the Western Cape. And we wanted some feedback from the National Department whether you are satisfied with the way in which that 30 million rand has been spent by the Western Cape Provincial Government and its entity Cape Nature. As I've said, unfortunately, that opportunity was denied. And then, Mr. Smith, the last message, we regret the scaling down of the high altitude teams in the past working on fire provided us with assistance in terms of high altitude teams for the eradication of alien vegetation. And feedback is that unfortunately that has been scaled down and that we no longer have that same level of support in that regard. With those messages, which I hope you will go and share with your colleagues, well, we want to say thank you very much. You are welcome to exit the meeting now. Same to you and others like Mr. Dion Rousseau, who may be interested. You are welcome to stay on. But members, I believe we are all due for a 5-6 minute break. So can I propose that it's now 15:14 that we return at 15:20 to deliberate and then start with perhaps the formulation of the mandates. And then obviously we also have other committee business to deal with, such as our program going forward in terms of previous decisions to go and visit the Cederberg, to observe the damage suffered by farmers and by institutions in that area. So honourable members, can we see each other again 15:20, 5-6 minutes from now? Thank you very much.
Thank you, Chair.
us the matrices. We now need to start on formulating our mandate to our representatives in the NCOP. And I've asked Ms. Nikak to first flight the matrix on the Agricultural Product Standards Amendment Bill. If I may be so bold to say that I think Mr. Retief Nell's concerns are noted, but that they don't really apply to what the amendment bill is trying to address. So if that is fine, can Ms. Nikak please proceed then to the Rooibos Council's input. The first one there is that they needed clarity on the practical implication. Obviously, that's very difficult in terms of legislation, but you see the assurance there that it seems to me as if industries would be able to participate in the determination of at least the fees by the designated assignee. You saw the references in terms of a budget that should be drawn up and be submitted for approval. So I hope that satisfies the members. Please put up your hands if you would like to comment. Then the next one is the auditing of the management control systems. Again, there was a concern raised, or actually a question asked, does the amendment imply the establishment of new systems? Now, it seems to me that the auditing of these systems have now been introduced in the bill. So it seems to me as if that maybe to some extent be addressed by the bill. And then the next one, number 6, the appointment of assignees. Now, there was this concern that they had no knowledge, but again, Ms. Swart said, I see that this is now addressed with requirements of having a particular knowledge of the product or management system used. So it seems to me if there is concurrence and that the concern that they've had in the past has now been addressed at least in part. And then I think we've already dealt with the fees and that there will be a budget. So hopefully that will also address that aspect raised. Then the next one is the comments by Councillor van Noordwijk, and it seems to me as if she's actually expressing her appreciation, and that therefore it doesn't require any negotiating view from the Western Cape. And now we come probably to the most important part, and then this is the issues with the order definition. Now it seems to me as if the definition has been refined, but perhaps we can include something to that effect. Although the National Department believes that the language proposed by the Western Cape is problematic. Now, I don't know, honourable members, if you would like to comment on this one. I think the issue is that the regulations promulgated by the Minister will be extremely important in this regard. And I think, if I may, we may perhaps just ask of our representatives at the NCOP to make sure that in drafting those regulations by the Minister, that the necessary public participation, and particularly from the interested parties for that particular management scheme or management control system, that those parties' views would be taken into account by means of a public participation process. Okay, I did see the hand of the Honourable America being raised and lowered again. Is happy. Good, thank you. So Ms. Nikak, perhaps if we could just ask that be captured, that in drafting those regulations, our our representatives must just make sure that there will be a public participation process and that the role players in that particular field be given an opportunity to assist in the drafting of regulations. And then the next one is the one where the Western Cape Department of Agriculture says that they propose, it seems to me, a subparagraph 3, having particular knowledge that is now by the assignees. Now, the assignees could be individuals, but as Mr. Makafola indicated in the past, it was almost never an individual person. It was like a industry organization that that organization must have particular knowledge as to confirm by providing confirmation through the review of the objective evidence that requirements have been made. Now, it is something that I think we should take into account and perhaps just raise with our delegates as well, that knowledge of the product and the knowledge of the regulations applicable, that is to be taken into account and is deemed to be a very important aspect, so that whoever is the assignee knows, when something can be designated as, say, for example, adhering to the word organic or whatever term may be used to describe the standard of the product. Honourable America?
No, Chairperson, thank you. I want to concur with you in the sense that we cannot always guarantee that it will be organizations, that it will not be individuals, because perhaps under the guise of hidden agenda or cadre deployment, there may be individuals that become assignees that may not have the necessary expertise and qualifications. So I agree with you. Thank you, Chair.
Good. Thank you very much. Ms. Niekerk, is that the last page of that? I believe
yes,
so.
Yes, it is, Chairperson.
Good. Thank you. Honourable members, are you happy for us then to move on to the Veld and Forest Fire Amendment Bill?
Maybe, Chair.
Honourable Maran? Happy. Good. Thank you. So, Ms. Niekerk, if you could flight that one for us, please. Honourable members, it seems to me as if what we must do is then pass on those two, can I call it, grammatical proposals, which the department accepts, but which, unless we pass it on, it might disappear in the process. Then from the Western Cape government, there was the issue that why municipalities and traditional leaders may facilitate the formation of a fire protection association. I think we have heard from Mr. Smith that they believe that it might be unconstitutional to force entities or to work together in fire protection associations. So I'm happy with the fact that it still says may, but members could feel otherwise. To a large extent, my knowledge of the fire protection associations is that it's a carrot situation. Because you belong to a fire protection association, you can be exempted from having a fire break along your boundary. And you and your neighbor or neighboring farms could, for example, work together and have one bigger fire break around a number of properties. And because you belong to a fire protection association, you have access to certain financial and support in the form of knowledge being shared, etc. So I'm happy with that one to remain may. Can we move on, Ms. Niekerk, please? Good, thank you. So again, Ms. Niekerk, if you could just again that grammatical change, and then the next one is also acceptable to the National Department, the owner, a state-owned enterprise, public, and it's recommended that the wording be revised as follows. I can go along with that proposed revision, and it seems to me the National Department is also happy to do that. Then the next one, under clause 4, again, the department is a little bit stricter, where it says the current act says the owners may form an association, where it seems to me as if the Western Cape Department of Environmental Affairs actually believe that it should be stronger, and they actually asked the question there: would parties then need to join a fire protection association within a certain period after it is registered in the area? And now the areas are specified as being, areas with similar fire risk and so on. So it seems to me, again, they take the approach of it being a voluntary association. And again, while the department might want to see stronger, can I call it language, to force people to form fire protection associations, for me, I think one can perhaps just give it through to our representatives in the NCOP as the views of the Western Cape government, Department of Environmental Affairs, but that we also appreciate the fact that these associations often probably work best when it's a voluntary organization. Can we go on to page 3, Ms. Niekerk? And please interrupt me or raise your hands, honorable members, if you would like this. There again, there's a grammatical or a typo error. The year 2021 should be replaced with 2023. They accept that. The next one is also a proposal that is accepted. The next one deals with the traditional leaders, which are given the power to enforce the Principal Act. Now, they propose that the reference to traditional leaders be deleted. Now, the department, I think, is quite right in saying that traditional leaders, particularly in other provinces like KZN, control large areas of land. So I don't know, honourable members, if you feel strongly about this one. I believe then traditional leaders should be kept in the this. This is an amendment of the Principal Act that they want to see. I'm happy for that to remain. Can we scroll down? Thank you. Now, this is now the accredited training. My recollection of the bill is that you must qualify as, can I call it, a fire protection officer, and that the one thing that I did pick up from the bill is that if you want to, and now I'm coming to the point that the Honourable America has made, if you want to search or seize something from somebody, that you must be able to identify yourself. But the principal bill used to say you must also show your appointment letter. And I would like to, and that is now deleted in the bill. And I'm surprised that there's no reference to that everybody's quiet on that. Quite frankly, I don't know, honourable members, but I would like our, can I call it, representatives in the NCOP to ask questions. Why if somebody must show his or her ID, why can't they simultaneously show their appointment letter, which empowers them to arrest me or to search me or to seize something which I may have in my possession? So if you're happy, honourable members, I would like our members just to raise that question in the NCOP deliberations, and I see a thumbs up there. Good, thank you very much, Mr. Kerr. Can we go on to the next page then? Again, comments on the Principal Act. They asked for the Principal Act to be amended to allow for two landowners to agree on the preparation of a single firebreak rather than two firebreaks on both sides of the boundary line. Now, it seems to me what they're saying is that the Principal Act already provides for exemption from the duty to prepare and maintain a firebreak. So my impression is that that is addressed and that actually the wish, if I can call it, from the Western Cape government is being provided for in the Principal Act. Then the next page, and that's still about the whole issue of fire breaks, Ms. Niekerk. I think that has been addressed. And again, as I've said, it seems to me that a Fire Protection Association can make its own rules. Mr. Rousseau, do you feel we're going to go too lightly over this?
Sorry, Chair, I just want to, I think there needs to be a stronger definition of exemption, because in the Act they talk about exemption, but that the exemption to make fire breaks, the authority to exempt landowners to make fire breaks lies with the minister. It doesn't lie between the two landowners or even the FPA. So I think the difference between landowners deciding to make one break between the two of them versus requesting an exemption, the exemption process is quite long. And as Mr. Smith said earlier, they have to visit the site and confirm that it does fall within the parameters of exemption. So if two landowners make one fire break between the two of them, that's still not an exemption. That is essentially the two landowners deciding, are they going to make fire breaks on the boundary? Half of the fire break is on the one landowner's property and half of the fire break is on the other landowner's property, or it's a division of labor to actually make the fire break. But I think we just need to draw a distinction between exemption and landowners agreeing to make only one fire break. That one fire break is still actually two breaks because the landowners have agreed, as opposed to going to the minister and requesting that they get an exemption, which is a much longer process. I hope that makes sense.
It does. It does. So what you're asking is that, and I can just imagine that one can burden the minister down with a lot of these requests, taking into account the number of properties involved. Am I correct in summarizing then that what you're saying is that at a local level, such agreements can be entered into, but my question is just then, where would such an agreement be registered? Would that be in a set of minutes of a Fire Protection Association? Because surely there must be some record of such an agreement.
Chair, correct. So FPAs have on their webs, and sorry, I'm also now speaking specifically about the Western Cape, so I'm not sure about what's happening in other areas of the country, but most FPAs have websites, and on those websites are fire break agreements. So it's that is then the relatively easy step, where the two landowners come together and agree that the fire break needs to be this wide and this long, and that is a fire break agreement, which then gets signed by the two landowners and approved, as it were, by the FPA. So that's the local arrangement, as it were, compared to going to the minister and requesting an exemption, which is a much longer process, and, as you say, very labour intensive from the minister's point of view, to exempt those landowners from having breaks. So basically what I'm saying is that there are things in place that allow for the local agreements to take place between landowners.
May I just ask, if you go back to the Principal Act section, I believe it's 12, 7, there is a sentence which says owners of adjoining land may agree to position a common fire break away from the boundary. Is that not already addressing the concerns that the department may have? Sorry, I don't know if you have the Principal Act in front of you.
Chair, so yes, landowners can agree, and a lot of the times in our circumstances, it's just not feasible to make the break, to make the fire break on our boundary. So it is then moved. But a lot of landowners assume that by moving the fire break or realigning the fire break to a road or a natural river or anything else, that is an exemption. That's not an exemption, that's just a realignment. So landowners will decide amongst themselves where to put the common break, and it is not necessarily, and a lot of the time is not on the boundary between the two landowners.
Okay, so would you like us to then still forward, just as you've formulated it there, to the NCOP?
Yes, I think it covers it quite well. I think that the concern was just that that the definition of exemption may be confusing between landowners. But I think that's again up to the FPA to explain that to the landowners, because they would obviously know the Act a lot better than the landowners would.
Okay. Honourable members, I take it then that we concur. Can I just then move on to Councillor van Noordwijk, who asked for guidelines for fire barrier roads and regulations. I think it's very difficult. What Mr. Smith has said, that he has seen fire jumping 100 meters, is true. Although firefighters have said to me in the past that a fire break at least gives them what they call a defendable line, something that you can try to extinguish the fire at, so that it doesn't spread any further. And I take it that it's very difficult, and that perhaps fire protection associations should have or continue to have the right to make their own regulations in this regard, which they currently have, if I'm not mistaken, Mr. Rousseau.
Correct, they do.
Yes, and I think it's very difficult, at a national level. If I think of the people burning grass in the north of the country versus burning fynbos, I think it is just beyond what a single piece of legislation can prescribe. Good. So thank you. And then can we then go on to page 8, which just says that Marshall Bay supports the inclusion of peace officers in the proposed amendment of Section 26. It seems to me it's already there to include peace officers. Perhaps Mr. Rousseau can just confirm that.
Chair, I wouldn't know about this.
Okay, can we just quickly check that Section 26? If I quickly go to Section 26, sorry, I'm with the wrong piece of legislation in front of me.
Chair, there's no reference to peace officers. This comment is superfluous.
Okay, so you're happy to propose that we do not include that in our formulation, or can I call it our draft formulation? We might come back next week with further proposals, etc. Okay, thank you very much then, honourable members. That brings us then to the end for today of that deliberation. Can I just ask, are there currently any further resolutions or actions while Ms. Niekerk flight the draft committee minutes of the 25th of July? Honourable Murray.
Chair, thank you. Just to ultimately thank the departments and the officials for their presentations and their hard work in the matter. It's not easy pulling together all of these comments and ensuring that there is a decent response to them. So that would be mine. Thank you.
Fantastic. Thank you very much. And I believe that, as in the past, we will also recognize and appreciate the input that we've received, both from individuals, representatives of organizations, etc. The list is not too long, so we will individually write to each of them to thank them for their input and say that it's been duly considered by the committee, and you know, we will obviously await the outcome of the final deliberations in the NCOP. Honourable members, you see there on the screen the first page of the minutes of proceedings of our meeting of the 25th of July. Can I have it was circulated before while Ms. Niekerk is just going through it. This was the one where we considered the first quarter reports of the entities, and then we also deliberated on Waikral and Amalienstein, the challenges that are still being considered there, or so experienced there. I recognize first the Honourable Murray and then the Honourable America in considering the minutes.
Chair, I propose that we adopt.
Thank you. Honourable America.
Chair, I second the proposal. Thank you.
Fantastic. Thank you very much. No dissenting votes, so it's been unanimously adopted. Thank you very much. Honourable members, yeah, I heard somebody's voice, but I'm going to continue as I don't see any being unmuted currently. Our next meeting will be next Tuesday, same time, 1 o'clock until 4 o'clock. And that will be then for us to deliberate, consider and adopt these draft negotiating mandate stage reports on these two bills. And therefore, honourable members, those of you that may need to share this with your relevant caucuses and get perhaps a mandate from them, please do so. Then, honourable members, you may recall that we as a committee decided that we would love to pay a visit to Cederberg municipal area, particularly to observe some of the huge damages suffered by the June floods. And I've seen pictures of particularly the Algeria camping site and also its adjacent accommodation establishments at a place called Sassewerf. Now, we tried to combine this with a visit of the Standing Committee on Infrastructure, which will be visiting Matsikawa at the end of this month. Unfortunately, it eventually, became clear that they needed some more time and that it would not be possible for those members that serve on both committees to, on the way back, join us then for our part of the oversight visit. And thank you very much. On the WhatsApp group, it was asked, and also I believe by private messages to members, for permission to use a Wednesday late afternoon, evening, and then a Thursday in the constituency period, which will then mean that we will leave on the Wednesday afternoon, the 6th of September. And I think members have indicated that they might be available from 15:30 onwards. And then that day will probably be dedicated just to traveling to Cedarburg municipal area. And then to return then on the afternoon of Thursday, the 7th of September. So we must still finalize the order, I believe, but at this point in time, the idea is to pay a site visit to Algeria, the Cape Nature Reserve there. And for those of you that have never been there, I hope you are excited to see the much spoken about campsite there. And then we also hope to be setting up a meeting with the Citrus Growers Association so that they can also perhaps inform us of the damages or the effects of the flooding. But I hope you would be fine, honourable members, if we also invite them to speak about the challenges with exports, both the challenges that, or perhaps hopefully it's going much smoother to export fruit from the Cape Town harbour. But then I do know that the European Union regulations regarding black spot and the measures that our farmers must take in order to export citrus fruit to Europe has come under the spotlight and is causing a lot of challenges and adding costs to the production of citrus fruit for export to the European Union. So I'm looking forward to that engagement as well. Ms. Niekerk, can you perhaps just fill us in? Have you been able to make contact already with both Cape Nature and the citrus growers?
Thank you, Chairperson. Yes, Cape Nature has confirmed that they will be ready and waiting for the committee to address the issues. And then regarding the agricultural part of the program, the department is in the process of setting up a detailed itinerary for the committee. And definitely a meeting with the Citrus Growers Association. And then there were also a few farmers that have requested the committee to come out and actually see the damage caused by the recent floods. So we are working on a detailed program, and I'll circulate that to members as soon as it is done. Thank you.
Thank you, Ms. Niekerk. Honourable members, are there any questions in this regard that you have? Thank you, Mr. Rousseau.
Chair, if I may, and I'm not sure if this is the platform, but I think it would be, I think it's just important to say how hard the staff at Cedarburg and Algeria campsite have worked. The damage was significant there, and I really think that they do need to be congratulated on being able to weather the storm, excuse the pun, but they it really looking at the work that they've done and how they've managed to get everything basically up and running again in a very, very short period of time. There's a highly motivated group of staff there, and they do need to be commended. Thank you.
Thank you, Mr. Rousseau. I have seen some photographs taken shortly after the 15th of June floods. And between Ms. Niekerk and yourself, perhaps you could just invite the reserve manager to perhaps share some of those photographs with us, which would then be able to give us an indication of the progress that they have been able to achieve in exactly the 2 months to the day since those floods. And yeah, I think that would then be the appropriate moment to observe and at that stage also give credit to what has been achieved. Honourable Maran.
Thanks, Chairperson. Yeah, thanks, Chairperson. Look, Chair, some of us did visit specifically the Cedarburg area not so long ago. We will go there, I think next week, again to not visit Silberg, but specifically Matsikama, because in the meeting that we had, the mayor of Matsikama was also present and basically request us to come and visit Vredendal and Van Rhynsdorp and to see the damages caused by floods in that particular area. So I don't mind going back there, Chair, to see the improvements since we've been there up till now, specifically when it comes to the Algeria area, because when we were there, we could only drive up to a certain point and where it was very, very cold, because they were still busy with that particular road that was been damaged by these floods. So yeah, love to go back there and see there. Also, there's a specific road, and I'm not sure what it's called. I don't think it's part of Kloof, but you could not access specific areas. And there's photos about a white pickup bakkie that basically, since the floods, when it happened up till when we visited, still they're stuck on the stones, no sand underneath. And if we can maybe go to that particular area, it's not far, it's not deep in from the N7. I think it's not more than 2 kilometers if we can go to that particular area. Also, Chair, what I've also said is that because I've been told that I'm a rural person, I'm staying in a rural area, it will be difficult for the WCPP transport to come and pick me up because that will be off route. Therefore, Chair, I've made an arrangement, and I've also discussed it with Serene, that I will drive from home. Instead of driving to Cape Town, I will drive to Pakketberg and leave my vehicle there like last time, and then he will pick me up there, and again on our way back drop me there. That will be easier for me, Chair. I've spoken to Enabling. They've asked me just to drop them an email because they don't think it will be a problem if he wants to claim from here to Pakketberg. Chair, so that will be arranged. Thanks.
Thank you, Honourable Moran. Honourable members, can I also propose that we then, as a committee, lend our support to these arrangements, because just from a thumbs up, I think, Honourable Moran, driving from the Dorens to Picketberg is probably even less of a distance or very similar to driving to Cape Town. And it just doesn't make sense for you to drive all the way to Cape Town and incur additional cost for the WCPP. And obviously your time is also a valuable commodity. So perhaps if we could support such an arrangement, it might strengthen your case. Honourable Moran. Also, Chair, the thing is, Chair, when you drop me off in Pakketberg, when you arrive in Cape Town, I will arrive at my home, because the distance from Pakketberg to Cape Town and from Pakketberg to where I'm staying is more or less the same. So instead of driving straight through to Cape Town, get my vehicle there, I could have been at home when I'm leaving my car in Pakketberg and then driving from there home. That also, the distance, Chair, as you've said, it's a few kilometers less than driving to Cape Town. So it only makes sense, Chair, to drive to Pakketberg, leave my car there, you pick me up, you drop me there, and I'm driving from there home again. Yeah. Good. No, with that, obviously, I think it makes sense. And I do hope that in future the rules would also be amended to provide for that. I do see that there seems to be, just from a quick calculation, about a 20-kilometer difference in distance. But please, I think that can be sorted with the WCPP administration. Honourable members, any other requests, remarks, resolutions? And if you would be so kind, Honourable Maran, to liaise with Ms. Niekerk, just to point out to other sites in that area where you believe, you visited last time, and where you think it would be of value to the Agriculture and Environmental Affairs Committee to go and pay it a site visit. Please bring that under Ms. Niekerk's attention. And with that, honourable members, it seems to be as if it has just turned 4 o'clock, which is the scheduled end time for this meeting. I want to say thank you very much for your active participation. Thank you very much for being here, for assisting me as chairperson. And as I've said, a reminder, we will meet next week, Tuesday afternoon at 1 o'clock again for the final negotiating mandate to be formulated. Ms. Niekerk will already before then be circulating what she took from today's meeting, which will hopefully not differ much from our final document in this regard. And with that, I want to wish you all a good remainder of this day. And again, thank you very much. This meeting is adjourned.